thank yous that on behalf of all of us, for the wonderful time we've had in the last, 24 hours or less. First of all, that reception, Standard & Poor's, we appreciate that, and the dinner sponsored by Guy Carpenter, the wine by PricewaterhouseCoopers, the entertainment. I didn't see The Magician, but my wife said he was outstanding. Guidewire Software Inc. was responsible for that. Thank you. The breakfast this morning, Towers Perrin, and the prizes we had last night, Reclaim and eJuster. I want to know, Diane Strashak, are you over the ecstasy that you experienced last night? Now, I'm only referring to your excitement when you won the big screen TV, nothing more than that. I think most of us who are political junkies saw some of the debates that were on television last night, and I thought that the media struck it right, that there were no winners or losers, but I really liked the attitude of the American politicians. They always, when they were going against one another, they were attacking policies, not people, and I noticed at the end, both the potential vice presidents complimented each other, and even during the debate, they would sometimes pay each other a compliment, whereas in the Canadian debates, it was dog eat dog, and if one said it was black, the other one had to say it was white. I don't know what that says about our two different forms of politics, but they say also that the Harper government never gets a good shake from the media, that the media are really quite left-leaning, specifically in Canada. So let me tell you a little story that maybe characterizes that. There was a venerable MP who was riding his bike through Toronto Zoo area, and he was going by the African lion display, and just at that time, a little girl who was looking into the lion's cage was grabbed by the lion by her cuff of her shirt, and the MP valiantly jumped off his bike. He ran over, he just took his fist and he lambasted the lion right in the nose. The lion let go of the little girl. He took the little girl, gave him back to his parents, her parents rather, and her parents were so delighted and so appreciative and for saving their daughter's life. Just at that time, there's a Toronto Star reporter there, and the reporter comes up and he says, "That's the most amazing display of valiant bravery that I've ever witnessed." He said, "What do you do for a living?" And the guy says, "Well, it was nothing. Any citizen would have done the same." He said, "I happen to be a member of Parliament." He says, "Well, what government are you with?" And he said, "Well, I'm with the Conservatives." "What party are you with?" And he says, "I'm with the Conservatives." And he says, "Well," he says, "I'll see that you get appropriate recognition in tomorrow's newspaper." So the MP went to sleep that night, was up early in the morning to grab the newspaper, and there were the headlines. "Harper thug assaults African immigrant and steals his lunch." That's about how they describe things when poor Harper's involved, eh? This morning we have a terrific panel, and this panel is going to discuss, are tort restrictions necessary? Randy Bundes is the moderator of the panel, and he joined the legal division of the Insurance Bureau of Canada in '87 and has been the Vice President, General Counsel, and Corporate Secretary for the past 5.5 years. As far as I'm concerned, Randy's greatest claim to fame is the fact that he's a native of Saskatchewan, just like me. We like to see Saskatchewan coming into their own right now. Prior to joining IBC, Mr. Bundes was a litigation lawyer with Saskatchewan Government Insurance in Regina. He is also Vice President and Secretary of the Property and Casualty Insurance Compensation Corporation and Board Secretary of the Facility Association. He is author of the Automobile Chapter of the Insurance Law in Canada by Brown and Menendez. Randy graduated from the University of Saskatchewan in '79 with his BCom and obtained his law degree from the University of Western Ontario. Randy, it's good to see you here today. Welcome as you stick a handle around this debating issue, and I'll turn the floor over to you.
Thank you. Well, thank you very much, Greg, and good morning, everyone. Now, I have the pleasure this morning of moderating our debate. The topic, as Greg mentioned, are tort restrictions necessary? And we're very fortunate to have with us today Richard Halpern, a partner with the Toronto law firm Thomson Rogers LLP, and Alan De Silva, also from Toronto and a partner at Stegman Elliott LLP. Now, their biographies are set out in the conference program, but I would like to highlight a couple of things about each of them. Richard is past president of the Ontario Trial Lawyers Association, and he's currently chair of the Ontario Bar Association Working Group on Auto Insurance. Richard has made a number of presentations to members of the Ontario Legislature, and he advocates for the rights of innocent accident victims and for the reform of auto insurance. Alan is a defense lawyer, having appeared in more than 100 cases that have been publicly reported, including cases at the appellate court level and at the Supreme Court of Canada. He recently represented State Farm in the appeal of Associate Chief Justice Whitman's decision in the Alberta Minor Injury Regulation case that he found to be unconstitutional. Alan also successfully represented IBC in IBC's interventions at the Supreme Court of Canada in the Vitlingham case, which involved the definition of use or operation of an automobile, and in the Childs case, which involved social host liquor liability. Now, in our debate today, there are going to be three phases. First, both Richard and Alan will make introductory remarks, about 5 minutes in length. Then I will ask them questions to begin the debate. Finally, for the last 10 or 15 minutes of our allotted time, we will open up the floor to questions from the audience. I would like to start by asking Alan to make his introductory remarks.
Good morning, and thank you all for coming. And I must say, an early morning event like this at a place that has a casino and dancing and all the other activities, it's encouraging to see the kind of turnout we have today, and we appreciate you being here. Randy said a little bit about the format. We're going to each do a bit of opening comments. We're going to do this Oprah format for a while, and then we're going to answer your questions. We hope there's a lot of questions, but I think Richard and I have agreed that, consistent with the Palin-Biden approach last night, if we don't understand your question or don't have a good answer, we're just going to go back to our canned notes and give you the answer that we have. So don't be surprised. If I'm talking about energy in Alaska and it's got nothing to do with this, then you know what's going on. I don't know the answer, really. So I want to just tell you the issue we're going to talk about today is the cap on damages in general and across the board in insurance legislation in Canada. My recent experience on this issue was acting for, as Randy said, State Farm in the Alberta cap case called Morrow and Zhang. And as some of you know, and some of you may not know, that related to the insurance reforms that took place in Alberta in 2003 and 2004. And the issue for the court, the Alberta Court of Appeal, was whether the minor injury regulation that capped non-pecuniary damages at $4,000 was unconstitutional under Section 7 and Section 15 of the Charter of Rights. I'm not going to talk about Section 7 today because the plaintiffs weren't successful in that argument, and it's a very convoluted argument which time would not permit me to get into. But the Section 15 argument, which the plaintiffs were successful at the trial level, relates to whether or not having the minor injury cap was discriminatory under Section 15, because Section 15 prohibits discrimination based on immutable characteristics such as race, sex, ethnic origin, age, and for this case, physical disability. So the question was, are claimants who are caught by the minor injury regulation a group in Canadian society that deserves protection under Section 15 because, first of all, it's a physical disability, and secondly, because they are a historically disadvantaged group? And I think to understand the case a bit, you have to understand what the minor injury regulation definition was. And that was those claimants in accidents who suffered from sprains, strains, or whiplash-associated disorders which did not meet the definition of a serious impairment. So that's who was caught by the $4,000 cap. Serious impairment is defined under the regulations as essentially the inability to perform the essential tasks of your work, your educational activities, or the normal activities of daily life. Now, when the case was tried in Alberta before Associate Chief Justice Whitman, and his decision came out in February of this year, there was extensive evidence by the IBC from both the plaintiffs and the defendants on the history of the legislation, why the legislation was brought in, and also from the plaintiff's side on what they said was a long history of stereotyping people with minor injuries, particularly people with whiplashes. And the trial judge, Justice Whitman, made the following conclusions. First, he said that minor injury claimants were a group that fell within the definition of physical disability under Section 15. Secondly, he said the minor injury regulation had the effect of stereotyping this group, which has been a historically disadvantaged group in Canadian society and who have been subject to prejudice. And you may ask, what was the prejudice? And the prejudice, according to him, was that they have been historically stereotyped as malingerers and exaggerators. Now, some of you may be wondering what was the extensive evidence that the trial judge relied on for this kind of conclusion. And the evidence was pretty sparse. In fact, we argued on the appeal that it was so weak that it was not enough to make the kinds of broad conclusions that he made. The evidence on the so-called stereotyping or historical disadvantage really came down to three things. One was a comment made by a member of the Alberta legislature, a careless comment made in the House about sometimes people with whiplashes are faking their injuries during the debates over the legislation. That was one member of the House. Two, a videotape that had somebody who was faking an injury to get no-fault benefits. And three, and this was perhaps to me the most astonishing part, newspaper articles and studies which showed that some people fake their injuries to get insurance benefits. Now, I would have thought that that proved that some people fake their injuries to get insurance benefits as opposed to proving that this was a group that was historically disadvantaged. Associate Chief Justice Whitman then went on to conclude that this unlawful discrimination was unlawful under Section 15 of the Charter, and he looked at the legislation as a whole, and he said that all of the benefits that the legislation brought in, such as increased no-fault benefits, improved access to no-fault benefits and diagnostic treatments without the consent of insurers, a better grid for premiums in a non-discriminatory way, lower premiums across the board by 15 to 20%, individual assessments of claimants' injuries, none of that diminished the discriminatory effect of the legislation. So I'm going to talk very briefly about, I'm not going to get into the arguments we made because I have a hunch that Randy may ask us that question. But I want to talk a little bit about how I got involved and the reaction that we had when we read Justice Whitman's case. I was first involved in the case after the trial when I was asked by a number of Canadian insurers to give opinions about the correctness of the decision. And when I sat down to write the opinion, I thought, this is a completely wrong decision. Then I thought, I should probably elaborate on that. And from my perspective, the case was very interesting for me personally because I spent a lot of my career dealing with insurance cases and also doing a lot of charter litigation. And it's not often that you get an insurance case where the Constitution comes into play and you have the two of them colliding. And to me, the decision just seemed wrong on a number of sort of very basic, commonsensical grounds. The first is the claimants that we're talking about, by definition, seem to be people who have temporary disabilities. And by definition, they don't seem to fit into the category that Section 15 was intended to cover. People with immutable personal characteristics, age, sex, ethnic background, things you can't change. And this group of people seem to be a group that are either going to get better, in which case they're back to work, etc., or they're going to get worse, in which case they would meet the test of the serious impairment and the cap wouldn't apply. And to me, the case that was most closely aligned to this was a case that went to the Supreme Court of Canada about 8 years ago called Dunmore, where the argument was that agricultural workers were a historically disadvantaged group which required Section 15 protection. And I actually argued that case at all three levels of the court for the agricultural industry. And we argued that agricultural workers do not have immutable personal characteristics because we showed the demographics that agricultural workers, people come and go and work in the field. It could be students, it could be foreign workers, and it wasn't something that you were stuck with your whole life. And so that case and that analogy was the one that came to mind. Secondly, from a common sense perspective, which is what the Supreme Court of Canada said you have to do when you look at Section 15 cases, this group of people did not seem to me to be a group that was historically disadvantaged. When I argued the case in the Court of Appeal, I made the point that anyone in the courtroom that day could be driving home, get struck from behind, and suffer a whiplash injury. But that did not automatically make any of us a member of a historically disadvantaged group in Canadian society, and that's just not what the framers of the Constitution and the Charter intended. And what goes with that is this presumption that the trial judge made that everyone is a faker or a malingerer just also runs contrary to a common sense notion that if somebody tells you that they have a neck injury or a back injury or they've been in an accident, your reaction isn't to say, aha, you must be faking. The reaction is sympathy. And part of that is because many of us have suffered that type of injury or will suffer it or have ongoing maladies of the kind. And that really brings me to my last point on this issue, is that I knew, and we all knew, that the Supreme Court of Canada had recently looked at this issue and had essentially said that in another case, people with chronic back injuries do not equate to Section 15 Charter protection because it's not the kind of physical disability which is unchangeable in which the framers of the Charter intended to protect. And I'll just leave on this section the quote from that case from the Supreme Court of Canada, where the court said, "No one who has suffered a back injury would be dismissive of the appellant's condition. Most of the population can probably be qualified as having experienced some form of temporary disability in their work or their lifetime. However, the ranks of the temporary disabled have little in common except to some degree of physical impairment for a shorter or longer period of time. They are really not comparable to others who have attracted Section 15 protection." Now, that was the leading case in the Supreme Court of Canada on this issue when Justice Whitman released his decision in February 2008, and it's nowhere referenced in the decision which he made, which we argued on appeal in February. So on that, just by way of overview, I'm going to end there, and we're going to come back and talk a bit more about the arguments that were actually made.
Thank you, Alan, and over to you, Richard. And as you noticed, a lawyer's minute is 120 seconds, unless they're billing you, okay?
That's a subtle hint for me. It's with some reluctance that I thank Joel Baker for inviting me to this. As Randy said, I'm the only plaintiff's lawyer in the room, and this is Armani Kevlar that I'm wearing. I'm reminded of the old comedian George Gobel, who was on the Johnny Carson show one night with stars much bigger than he, Bob Hope and Dean Martin. He looked pretty insecure up there on the stage. And he turns to Johnny Carson and he says, Do you ever get the feeling that the world is a tuxedo and you're a pair of brown shoes? That's me tonight, this morning. I'm going to take a different approach to the Morrow case than Alan has taken, and I'm not going to get into discussing the merits of the case because, quite frankly, I don't think that's the issue for us here today or going forward in auto insurance reform in Ontario. And my primary concern is with what's happening in Ontario, though I think we can take some lessons from the Morrow case. As most of you know, 2008 is the year that auto insurance is to be reviewed under the Insurance Act by the Superintendent of Insurance. And the fact is that I expect that most people in the room here would agree that auto insurance is desperately in need of reform. The issue is, what reform should we have? For the constituency that I represent, we are looking at easing of tort rights. We want deductibles reduced, thresholds removed, certainly the defining regulation removed that came in 2003. From the insurance industry's perspective, obviously, there are concerns about increasing loss ratios, there are concerns about declining returns on investments, and there are concerns about, and what we'll talk about a little later, about first-party benefits that are really choking the system. They're out of control and they're unsustainable. I would suggest that leaving the product as it is not an option for either side of this debate. Premium increases contemplated at the level that the industry is putting forward will not be tolerated by the public. Politically, premium increases will not allow politicians to withstand the outcry from the public if they increase at those rates. And premium increases in excess of 10%, as Ron Miller suggested yesterday, simply can't be. But without accepting the predictions about what rate increases are required, I am generally not in favor of reforming the product in order to prop up profitability for the industry. At the same time, I recognize the waste and expense of the current system to the industry, and I find myself supporting the industry for the calls for reform to auto insurance in Ontario. Where we differ is how to achieve that result. When I look at auto insurance reform, I consider three fundamental factors, and they must go together. The first is the protection of the rights of innocent accident victims. The second is maintaining affordable premiums for the driving public. And the third one is maintaining a healthy and viable insurance industry. In my view, we have to address all those problems in any approach to reform that we have. Unfortunately, the matter of tort rights has all but been ignored by the insurance industry. These rights have been treated as largely insignificant, and in my view, at some peril, at least politically, to the industry. The fact is that there is a considerable push for reform of insurance just 5 years after the 2003 changes, which saw further limits on tort rights in Ontario. The fact that we had additional tort limits in 2003 and we now have a push for further auto insurance reform suggests that the approach that we took in 2003 did not address the problem. We're going to have some discussion about Morrow, the Alberta Charter case that was struck down, and it's obviously created a lot of buzz. But I'm going to suggest to you that the real significance of the Morrow decision in the final analysis is that it's a lesson about how our courts are going to view attempts to reduce premiums on the backs of innocent accident victims, not just whiplash victims, but innocent accident victims. And all in the name of sustained profitability for the insurance industry. By the way, a laudable goal. Nothing I say it should be taken as an attempt to deprive the industry of appropriate profitability commensurate with the risk that you take. But I want to talk about the judicial treatment of limitations in tort, both in Alberta and in Ontario. The Charter case in Alberta, looking at it in broad strokes, to me is an expression of judicial dissatisfaction with the notion of controlling premiums at the cost of compromising tort claims. But in Ontario, we have our own examples of that same thing. Just as the Alberta case is disruptive to the conducting of business in the auto insurance industry, we have similar concerns in Ontario that have been raised by, in particular, the IBC. And what I'm talking about is this. In Ontario, concern has been expressed by judges softening the verbal threshold in their interpretation of the threshold. In Ontario, there has been concern about judicial generosity and thereby eroding the deductibles that apply to claims for non-pecuniary general damages. In Ontario, there's been concern about judicial interpretation on the matter of catastrophic, where judges have, according to at least the defense bar, have inappropriately combined physical and mental to get more people over the catastrophic barrier. If there is any merit to these concerns, it is the same phenomenon that happened in Morrow, but on a smaller scale. Now, these trends, as identified by the industry, are characterized as adverse trends in judicial decisions. And these adverse trends tend to result in what has been characterized as unexpected interpretations of the product. In fact, I've heard much at this conference about these changes, these challenges that lead to uncertainty, to vulnerability, to volatility, and to instability of the product. But I urge you to consider this. When it comes to the subject of limiting tort rights, there are lessons to be learned from Morrow or any judicial or arbitration decision that appears, at least to you, to go the wrong way. The industry promotes limiting tort rights as a cost control measure. But tort rights are not simply an accounting entry that diminishes profitability. Tort rights are much more than that. And the failure to appreciate this important fact with respect contributes to this atmosphere of instability and volatility. The tendency for judges and arbitrators to interpret liability limiting legislation in favor of the injured person needs to be seen as a recognition of the value of tort principles and important public policy principles that go along with that. While the notion of delivering lower premiums to the driving public by reducing costs is appealing, slashing costs without regard to important matters of public policy, access to justice, accountability, deterrence, and fairness is unacceptable. One should not take a cavalier approach to tort. The message to take from Morrow is this. Where it is proposed to pass reforms that compromise rights and access to justice, those who propose those reforms ought to have a high burden of proof to show cause why they're justified. My suggestion to you is that that burden of proof has not been met. I'm reminded of the presentation I saw yesterday at lunch by Mr. Donoghue about the IBC approach to global warming. It's an inspired approach. It's an approach that recognizes all of the interests, public interests. I would urge the same approach to auto insurance as the approach that the industry has taken to global warming. I think that everybody would be inspired by it. In that approach, I know on the auto side we've looked at, or at least the industry is looking at safety concerns, but that doesn't cut it. I don't think that in the approach we've really taken a broader look, at all of the interests that are associated with auto insurance. And again, the principles that we need to look at include a recognition that tort has an ability to deliver justice and fairness, that the public has an expectation that the more seriously injured will be reasonably compensated for their losses, that there is an important